Okay, welcome everyone to DAYL's Coffee with the Court with Judge David Counts from the Western District of Texas. Traditionally, we had these Coffee with the Courts in person, but since we can have them online, I thought we would bring in someone from outside of Dallas. And so Judge Counts, you're in Midland, right?
Sitting in Midland today, right? I sit in Midland and Pecos and Alpine.
Awesome. So so thank you everyone for joining. We have a CLE credit code. I'll just get that. I'll say it at the beginning and then at the end as well. It is 174088309. So thank you everyone for joining, and thank you to our sponsors for this event, Kane Russell Coleman Logan, Castle Law PC, Ryan Law Partners, Aiken Gump, Strauss, Hauer and Feld LLP, Bell Nunnally, Cobb Martinez Woodward, and Greenberg Trareg. So my name is Jenny Smiley. I work at Cobb Martinez Woodward, and I got to know Judge Counts when I was clerking in the Western District. And I'm going to ask him some questions, and we're going to have a good talk, hopefully. And then you all can ask some questions at the end. I want to save 15 or 20 minutes for questions, and so you can use the Q&A function that's on the bottom of your Zoom screen to type in questions, and then we'll be able to ask them. So, Judge Counts, thanks for being here. Will you tell us a little bit about your background and how you became a judge in the Western District?
Oh, sure. Good morning, everybody. I'm glad to be here. It's an honor to be asked, and it's fun to actually get to talk to some people. I can't see all of you. I can see Jenny and a really nice logo for the Dallas Association of Young Lawyers. And so be sure and ask questions as we go if you have any, and I'll answer as many as I can. I've been real excited because I got to get a haircut the other day. And if you're like me, I felt like I was going to have to start braiding it before long. But I wanted to do my part too, to defeat the virus. And so we didn't do a haircut until last week, but I feel pretty good now. So I wish, looking at myself on the screen though, I wish I'd had maybe some makeup or something. Next time, Jenny, we can do that. So I grew up in a real small town in the Northern District called Knox City, Texas. And it's north of Abilene, about 80 miles west of Wichita Falls, west-ish of Wichita Falls, 70 or 80 miles. And so from there, I went to Texas Tech University in Lubbock. And as everybody who has ever worked here knows, we're big Texas Tech people here. Not solely Texas Tech people, but we are very big on that. And then went to St. Mary's University Law School. Maybe some of you are like me, and I actually kind of wandered through my first year and a half of college and really enjoyed college. And then since I wanted to go to law school, I determined I had to buckle down. In the last 2.5 years, pretty much did 4.0 from that point on. I'll never tell you what I got the first year and a half because it was awful. But I really enjoyed college, and I always look back fondly on those times. So I went to St. Mary's University, graduated in the top 55% of my class, something like that, which my wife reminded me recently was the bottom half of the class. But I think I was in the top 54, and so I'm being kind and saying I'm top 55%. And went to work in a small firm. So I grew up in the Northern District of Texas, but from the time I went to law school, I've been in the Western District career-wise and everything else, except for a year in Afghanistan, which is what they do to you if you're not a very good lawyer. They send you there. So I went to work for a small private civil firm in Austin for a while, and then decided, I really wanted to try lawsuits, and wasn't getting enough in this smaller firm that did a bunch of administrative work. It wasn't the firm's fault. We did a bunch of administrative work, and I got to do that, and that was sort of similar to trials for me. But when I kind of decided I wanted to go try lawsuits, even if it cost money, even if it didn't raise my salary, I went over to the district attorney's office there in Austin, worked for Ronnie Earl, who some of you have heard of. He just passed away, God bless him, recently. But he was there for many, many years, and I got to be in there from the mid 80s to the mid 90s as an assistant DA. Got more and more responsibility, lots of trials, there's tons of trials that, you don't have any other opportunity to get, frankly, unless you're doing something like that. Then after that, got what I considered to be the crown jewel position, my ultimate job that I would never leave, as an assistant U.S. attorney in San Antonio. I did that after being an assistant DA for about 8 or 9 years. I went to the U.S. Attorney's Office for 14. And then along the way, had an opportunity. I always wanted to get back to West Texas, where I felt like I was from. And so then wandered back out here when Judge Rob Janelle was appointed by President George W. Bush in 2003. And so I sort of started having my eyes on that, his magistrate judge's position. But we had a great magistrate judge at the time named Stuart Platt, who is up in DOJ right now, I think in their Office of Inspector General, still going, and doing a great job there. So I figured he was too young. I would never have an opportunity to come do this. I think it's sort of normal to want to be a part of something you revere. And I always revered the judiciary. Didn't think it was for everybody. I still don't. But I always kind of wanted to get there. And after 23, 24 years of practice, Judge Platt ended up leaving way earlier than he was as far as age-wise. And I got to come over here. I was hired, and then after 8.5 years, was elevated to the district bench. But that was a 3-year ordeal, as many law clerks I think are watching today, including Jenny, of course, that lived through it with me, helped me, organized me, and it was an interesting time. I kept going through that 3-year ordeal, and it took my predecessor, Judge Janelle, it took him, 3 months or something. It was just nothing compared to what it is now with the political landscape as it is. I was I was nominated by President Obama. Had my Senate confirmation hearing along with some great judges and great attorneys. Judge Karen Scholler from Dallas, sitting now in Dallas, and then Judge Wes Hendricks sitting now in Lubbock, and then Judge Irma Ramirez, U.S. Magistrate Judge Ramirez in Dallas, who's was great as well. And I still hope will be on the district bench at some point. We had a really good panel. We did the Senate Judiciary Committee hearing, and then the election happened a couple of months later, and had to start over from scratch and come through, and was nominated by President Trump and confirmed. This time I didn't have to go through the Senate Judiciary Committee hearing. That wasn't the worst part. I actually kind of enjoyed that hearing, by the way. The preparation the day before, what some people refer to as a murder board. I never really referred to it as that, but it was like one of the worst days of my life. It was just very difficult, but it was so important, as so many things are like that. But I will say I left out one small thing. When I grew up in my household, my dad was in the National Guard, and so when I was a kid, and for 32 years, in fact, he was, so he had a lot of influence on me, obviously. Probably the reason I wanted to be a lawyer. He wasn't, but he always wanted to be. And there weren't the opportunities back then for some folks, and he didn't get a chance to go. And so that's probably why I ended up going to law school. But I also wanted to join the military and serve. I wanted to be in the military. I didn't want to be full-time. I wanted to be a citizen soldier. And so I joined as an assistant DA. I got to join and get a direct commission of first lieutenant. And that's when I went to Afghanistan from, March of 2005 to March of 2006. I was boots on the ground and at Bagram Airfield, Afghanistan, and I wouldn't want to do it again, but I wouldn't take for it. It was just an awesome experience, a wonderful experience that God really opened up for me and showed me some things. But I retired from the National Guard this past September after 30 years. I couldn't quite reach Dad's 32, but I used to joke around whenever I'd been in the military like a year. Whenever we were together, I'd say, "Well, Dad, we've been in together we've been in 33 years," and that sort of thing, and then kind of added the years, and so together we were in 62, I guess. But it was a lot of fun. I learned a lot. I met a lot of great people, and I was ended up being the state judge advocate for the state of Texas. over the Army and Air National Guard throughout the state, and basically setting policy and recruiting personnel, determining where people would go, distributing assets and personnel throughout the state, and then really throughout the world, because we hit a record number of deployments from 9/11, 2001 through even currently. So a lot of things, a lot of changes, and I think you're fortunate to be. A lot of times you're fortunate to be just in the right place at the right time, and so I will say also, lastly, and I'll quit rambling, but I just want to make sure you know the most important things to me in my life are my wife, my 3 kids, and they're all married, they're adults, married, and have given me grandchildren now. And so I have 5 grandchildren, 2 of which are staying in my house right now, which is maybe why I'm looking a little tired on the screen here. But just a wonderful, wonderful thing. And nothing means more to me than all those people. There are some in-laws. Let's see, we've got a son-in-law, 2 sons-in-law, and a daughter-in-law. I love them too. They're not quite as important as my kids and my grandkids, but they have a vital role. So anyway, so I got here, and I'm very fortunate to be here. I want to say also, Jenny, that I think a lot of our clerks and former law clerks, current and former, are watching. It probably makes up the whole group, in fact, and who knows. But they're vital. If you maybe weren't a law clerk out here, but were somewhere else, you're obviously a vital position, a vital person in, the moving of the business of the court. And there's no way any judge can do this job. And those of you who've been in the position of law clerk or judge know that I'm telling you the truth. A lot of times it feels like meatball surgery because there's stuff that just continually comes. We have a large criminal docket. We have a large civil docket, which I'll talk more about in a few minutes. But that's the only way this can work, and it's critical. And I rely heavily on all the clerks, as Jenny knows.
Well, yes, thanks so much for sharing so much about your background. One of the things I think is really interesting is how you're a magistrate judge and then became a district judge about 2 years ago. So what were your responsibilities, or compare and contrast your responsibilities as a district judge versus when you were a magistrate judge for us, please?
Oh, that's a really good question. The district judges can't operate without magistrate judges. I don't know how we ever did. And it comes from the old Commissioners Act, and we had commissioners for years and years and years. And then later we became magistrates, and then later they added the term judge, became a U.S. magistrate judge, because more and more the roles of those judges sort of dictated the title change. Because frankly, a magistrate judge, a United States magistrate judge, does everything a district judge does, save and except very few things, which would be actually presiding over felony criminal lawsuits, and then a few other little things with wiretaps and things like that. But very little. They can do almost everything, and they do almost everything. Whether it's impaneling grand juries, impaneling juries, trying lawsuits, civil cases, of course, can be tried by consent to a magistrate judge, and often are tried by magistrate judges. I mean, all the time. And we'll talk a little bit more about that too. I want to throw a pitch in there for doing that. When I was a magistrate judge, I looked at it kind of like this. I thought, okay, now, and I worked for one district judge, but you also work for all the judges in the district. That's why all the district judges throughout that district have a say when you're being hired. They can sort of blackball you, I suppose, if they've had a dealing with you. And most of them don't know you, but some of them do. And so they have a say because you may be doing work for them as a magistrate judge. So if you ever want to be a magistrate judge, you'll want to appear in as many different courts as you can, in front of as many different judges as you can. And I think that's wise anyway, just for a good litigator, because I think you just get better and better with different judges. And it means a lot if you've done that. Plus, more of them know you. and we'll know whether you're maybe the right person for a magistrate position or not. And so the way I looked at it was, since I worked for one judge primarily, even though I get other work from other judges, um, I I looked at it as everything on my desk was his, not mine. The only way I really had, and this is, there's some exceptions to this, but my caseload was his caseload. And keep in mind, he had another magistrate judge over in the Pecos division that Jenny works for, in fact. So you had two magistrate judges working primarily for one district judge, and everything we owned was his. And so I looked at it as, okay, what can I do? I'd come in the morning and say, what can I do to take stuff off his plate today? What can I do to take stuff off of his desk? Something I deal with, he won't have to, and he's not going to have time. And as I've ascended to this bench, that was really true. I mean, there's just no way to get it all done. So you got to have somebody there. And some people, like in Dallas, you've got several magistrate judges. I know many of them, almost all of them. They're all fantastic. And you got to trust them. And so now there are a few things that a magistrate judge has that like, for example, petty cases, misdemeanors, things like that aren't reliant upon the district judge having any say over them. And so, say, for example, an illegal entry, 1325, a Class B, we have our magistrate judges here see a lot of those, and 1324s as well, of course, and 1326s, but those are felonies. But as far as 1325 illegal entries, magistrate judge will take those pleas or try those lawsuits and will sentence if somebody's convicted, if they've pled guilty. And the district judge never sees those. Of course, you do a lot of writing. There are a lot of things that are referred to you by the district court that you've got to send back to him or her, as the case may be. And so if you do that, then that's what your clerks are mostly pushing on, is the way I saw. The judges are in court so much, and it's such a high demand for you. There's such a high demand for you to be in court, which is fine. Which hopefully most judges like people and like to be in court. That's sort of something that I hope we have in the judiciary, as sort of the face of the icon of our judicial system is typically the judge. That's what we all think of, I think, or most of us. But if you most of the time your clerks are sitting in isolation a lot of times, and it's a lonely life. I know it is. But they get in there and they either put headphones on or they close the door or whatever, and they work. And so the magistrate judge then is left to review, maybe edit, discuss those things, and then do a report and recommendation to the district judge, who has law clerks who are also reviewing all that stuff. And then the district judge is making the final ruling, and then all that stuff, of course, is going up to the circuit, where they'll tell you if you're right or wrong, and that's the way that works. It's a beautiful system.
So you kind of started to touch on the issue of consenting to the magistrate judge, and I'm going to tell you that's the number one question I get as a law clerk, a former law clerk, from my partners is, okay, this is our district judge, this is our magistrate judge. We got this letter, we got this order. What should we do? And since I worked for a magistrate judge, I often say, of course you should. Like, how? So what should the parties, like the lawyers, consider when they're talking to their clients about making whether they should consent their case to their civil case generally to the magistrate judge?
I think you probably have to take a measure of the magistrate judge, the subject matter of the lawsuit, but also the magistrate judge. For example, when I came to, I had some civil practice in my background, but a heavily criminal prosecution and some even criminal defense work. And so I think that should go into, okay, where's this magistrate judge come from? The way it started was when I was here, my district judge had a civil background. He didn't have a criminal background. I had a criminal background and not much of a civil background comparatively, compared to many of you. And so I think that should go into weighing of the decision. the magistrate judge I have now here in the Midland Odessa division has a heavy civil background. Now, he was a former law clerk for the magistrate judge for the Judge Platt that I mentioned before. And so he had done that 20 years before he got here as my magistrate judge there. Magistrate judge over in Pecos, actually out in covering both the Alpine Courthouse and the Pecos Courthouse. He and I were young lawyers in Austin together. He was a criminal defense attorney and I was a prosecutor. And so we have a lot of background to share, but we're both more criminal heavy type, lawyers, or we're litigators on the criminal side of the docket. So I think some of that goes into your calculus. However, I don't think that's got to be the deciding factor. I think a lot of it has to do with the lawsuit itself, what the subject matter is. You want to do some background checking on the judges. I think that's only normal. I was told, my preacher told me one day, I didn't know it. He walked by and said, "Did you know you have a Wikipedia page?" And I said, "Are you kidding?" No, I had no idea. And so this stuff gets built on you, whether it's true or not. I've never gone to that and looked at it. Somebody told me they had the wrong picture up on one of my sites. And so I was going to make an identity theft complaint, but I'm afraid to go look at those things because I always probably get upset if any little thing is wrong, even though it doesn't matter to anybody but me and my mom, maybe, so one of those silly things. But my pastor was telling me he was going to go on. He said, because Wikipedia, anybody can go on there and make changes. So I'm going to go in there and put on that you won bowling trophies and, goofy stuff like that. So I'm really afraid to go look at that stuff. So I think you look at that, maybe talk to other litigators, look at the background of the judges, talk to other litigators who've had experience in those courts. We get a lot of Dallas attorneys, Fort Worth, out here, Houston, San Antonio, New York, Oklahoma City. We get them from all over, as many of you know. And last Friday, I had probably 2 or 3 from the Fort Worth area. It just happened to be that day. So we get a lot of things. And I think, too, it matters if you've been a law clerk like you, Jenny, and many others that are watching, or you've seen behind the curtain. And so that done properly, whether the district judge or the magistrate judge presides over that trial, is likely not going to be a huge issue. The one thing out here is, though we have a heavy civil docket, we have a much heavier criminal docket. And so I've always said I call it a criminal heavy docket, but that sort of doesn't do justice to the heavy civil docket that we have. It's a steady push. It's a steady grind every day. So the one thing that we can offer you is, and it doesn't matter because none of us get paid on commission. So it doesn't really matter to us. And I do want my magistrate judges to be judges. I want them to judge because that's what they want to do. That's what I want them to do. That's what helps me. And it's a great team effort. And so if you've got a civil case, you're always, no matter what federal court you're in, you're always going to be held hostage to whatever criminal docket there is. Your case is, not you. And so a magistrate judge can almost always, I don't think it matters what division you're in or what district, get to you quicker, get to your case sooner than you can by way of the district judge. Now, it's even worse and amplified, I should say, or magnified out here, because there's only one of me who can try, one person who can try the criminal felony jury trials. And so I may have 3 or 4 lined up on a given day and a couple of civil cases right behind them. And I can't get to the civil cases unless I get done with those criminal cases. And so the one thing we don't have enough of, we got lots of land out here. We can spread out. The one thing, we're not living on top of each other. Thank God we've had way lower coronavirus numbers, probably because we're at a distance anyway, kind of, unless we don't want to be, if we're careful. And we've all learned a lot and evolved through this. But the one thing we don't have is, just like every other court, there aren't enough days in the month to try everything and to get to everything we need to because of the influx. Let me just say real quickly, last year, in calendar year 2019, I sentenced 1,400 defendants. Now, that's more than most places will do, and you can add a bunch of them together that'll get there. But that's just the criminal side, and those are only the sentencings. I say that only to say we did a lot of trials. We did a lot of civil trials. We continually pushed on civil cases. But those criminal cases that have speedy trial attachments, both statutorily and by Constitution, those rights, and those are good. Those are great that's a great statute. That's a great constitutional right. I wouldn't want to change it. But that's going to, by the very nature of it, hold everything else off at times. And so we do our best to work in. We're very hesitant to, we try to work in those civil cases, civil hearings. We're very hesitant to move a civil hearing. If somebody comes up and says, I just need a few days, we're like, well, we'd really like to help you out, but I think we'll be better off to go ahead and have the hearing and let's push this case a little bit more in the direction of the goal line and get it finished. We do a lot of, I do a lot of, the Zoom is new to me, but we had a lot of phone conferences before anyway, because we have lawyers from all over. Do I care if you want to fly in or not? If we have a preliminary hearing, it doesn't matter to me, as long as we get it all done. We can hear you, and now we can see you. We do this, and so we've had a lot of Zoom hearings. I had a couple of settlement conferences last week. We had those people they all decided to come in, because I just think a settlement conference is a little more difficult to do when you're proving up things and whatnot. And so there was better communication, I thought, in person. I thought that worked really well. So I'll just say that's sort of the considerations. We can likely get to a resolution in your civil case, help you get there by getting you to the magistrate judge. I mean, they're going to be quicker about it than the district court's going to be. It's more of a clunky district judge having more of a kind of a clunky, more like turning a battleship in a big old ocean. It just takes longer to get to because there are just more things piled up. Does that answer your question at all?
Yes, definitely. I think that gives a lot of points that people can talk about with their clients and do some research on. So no, I definitely think so. So I guess you've told us a lot about the Western District already, but I was wondering if you wanted to show the map or explain anything else about kind of your docket, and then I wanted to get to your advice on some specific, more substantive things too.
Okay. Yeah, show us the map. We've got a map prepared for you. Hopefully everybody can see it. Excellent. Excellent skills, Jenny. Great. Okay, so you can see this is the Western District of Texas. There's some of it, there's no rhyme or reason to it. Because if you look at Midland, that's really the Midland-Odessa division. Don't ever call it the Midland division. It's the Midland / Odessa division. Pet peeve of mine, but I also know that's accurate. So that's what we want to call it. And so we have 7 divisions, but we have, I'm the only judge who has 2 divisions, and I'm the sole district judge for Midland, Odessa, and the Pecos division. Of course, look at Pecos, that huge blue, light blue, Columbia blue looking area of the map. We've got 10 counties there, I believe, and you got 6 more in Midland, Odessa. So Pecos division, of course, is, like I say, there's a lot of land, but you also have a different time zone. If you'll notice, the El Paso and Hudspeth, I guess it's kind of fuzzy here. Those are in the Mountain Time Zone, of course. And so we have different time zones within one division, in fact, but we have a lot of people spread out. We don't have a lot of folks in any dense fashion other than, say, Midland and Odessa, especially in the Midland-Odessa division. So interestingly enough, if you went just straight across from the Midland-Odessa division to Waco, the Waco division, which is over there in the pink, it looks pink to me, at least on my screen. You'll notice a bunch of white. The northern division really dips down. And so a lot of people are curious as to why San Angelo, isn't in the Western District of Texas. That's think that at some point you've got to divvy it up like this in order to make everything a little more even. And of course, then the Southern District is down below, and then the Eastern District over on the right side of your map. What's interesting and I think unique about you can look at all the border of that all the way from El Paso way down to really what's the Del Rio division and part of the San Antonio division almost is just about touching it, down to a little town in the area called Quemado down there. Go past that and you're still in the Western District. So I forget how many hundreds of miles that is, but that's a lot of miles. The entire the border I'm talking about, the entire district is either 92 or 96,000 square miles. Whoever you talk to, they have different ideas about that, but it's a lot of miles, and there's a lot of trafficking going through those areas of the border, whether it be human or narcotics, and so we have a lot of that. And then you've got, interestingly enough, bigger cities in Austin, San Antonio, and really Waco is getting to be a pretty big area. And then the bigger cities over on the western side would be, of course, El Paso, but then Midland and Odessa. But you got these big cities where you have lots of white collar issues, lots of economic industry, and you have a lot of your hubs there. And so you end up with a lot of civil lawsuits, especially in our area where we have the oil field, which is really big. Of course, right now, you know how oil prices are. And my theory is, and I've seen this now I've been here 11 years and I've been in the district for 35, I guess, but or thereabouts, something like that, 34 maybe, practicing somehow. But I have been in this courthouse for some 11 years. When the oil prices are really high, nobody wants to stop making money and come argue about money in courthouses. But when prices go down, people start getting laid off. We have a lot more issues, whether they be labor and employment type issues, but also you'll have other issues that pop up all the time, discrimination type things, and then all of a sudden those rise. And I think you're about to see, of course, the prediction is, and I think it's pretty easy. Anybody could have predicted the rise in bankruptcies that we're going to be having, but because of all the oil industry's difficulties, and it has always been sort of a boom or bust economy, but it drives us here. I'm one of the few people in town that isn't somehow connected to the oil industry, and I'm repeatedly told, well, you really are, because you wouldn't even be here if we didn't have that. And so I have to agree with that. And so I think we have sort of the good and the bad with it. And while I think everybody has worked really hard to make the oil business as even as possible, even keel, be on an even keel as much as possible, you can't control what the Saudis do. You can't control what OPEC does a lot of times, and some of these other nations that are going to have a say in oil prices. And so there's always going to be this turbulent area. And I know I'm talking to a lot of people, especially those who do this type of practice, who know a lot more about it than I do. I'm just saying from watching from the catbird seat for the past several years, that's what it looks like to me. And then what you end up with on the other end of the spectrum as we go through this with the downturn is you have the stronger companies sort of backing off and keeping their powder dry, holding on to their chips and waiting while some of the more transient companies filter out. And that happened. But I've seen it now at least a couple of times in that decade that I've been here. So that's going to happen. And it sort of ends up making the business in this area healthier, though it's certainly not healthy for those people who have been impacted directly by it. But if you go to Austin, you're going to have a lot more white collar, a lot more stuff. You go to Waco right now, patent capital of the world, patent infringement capital of the world. They're not infringing all the patents there in Waco, but Judge Albright is sucking in all the patent cases he can, and he should be doing those. He's fantastic at it. And he does a good job. He's got a good nature about him, and he pushes those cases. He works them hard, as he should, as all of us should, and he does a really good job with that. So you've got, and then San Antonio has a whole mix of things. So you've got a lot of different areas for one district. It's like it could be several different states. You've got a lot of immigration in certain areas, and then you've got less in others. One quick example, and I'll hush about this, but you go over to the Pecos division, and you have a lot of 1324 cases, a bunch of narcotics trafficking, harboring, transporting. You come just over here in Midland, and you still have some of the illegal reentries. You don't have a lot of the human trafficking type cases. El Paso, huge. Del Rio, huge, of course, as far as those are concerned, but not that many in San Antonio, as I recall from when I was there. But then you go to Pecos, El Paso, or Del Rio, and you're just, they blow the roof off with human trafficking type cases. Sometimes illegals, sometimes sexual exploitation related things like that.
Well, thanks for sharing about the Western District. I know it's one of my favorite places, and I don't know if I'm there, but so I guess I wanted to go through a little bit of kind of your advice or tips, pointers on a few different issues. As young lawyers, we're often in charge of discovery and handling that. So what's kind of your approach to civil discovery and handling a discovery dispute, kind of your general thoughts?
Absolutely. And I was just looking at the clock. I realize we're running closer out of time. I apologize. But I want to make sure that we get these points across. I think you always want to handle everything at the lowest level. I mean, and you really, when I was litigating, I did not want a judge making a decision for me that I could make if I could. Now, judges judge, and at some point you got to let the case go to them if you can't settle it and whatnot. But I always did everything I could, including bringing in outside people to help me with discovery disputes if necessary, to try to compromise and work on a discovery dispute or any type of dispute, really preliminary dispute, because I didn't want to let go of that and not have a say in it at all. Because a lot of judges, you know them, a lot of them will split the baby regardless of whether you're 100% right or not. They'll split the decision so that everybody can have a little bit of everything. Sometimes that's right and fair, but sometimes that's a fallback, I think. And so I'd always have full faith and belief that I was going to win. I think you should. I think a healthy ego is required. I didn't say an out of control ego, Jenny. I said a healthy ego is required to be a litigator, and I think that's good. And you gotta want to be able to, you gotta be really organized and really want to sort of maybe like showing off a little bit, maybe just showing off that organization and how everything pieces together and convincing people, persuading them. But I always wanted to try and handle it, discovery disputes especially, but any disputes, preliminary disputes outside of the courtroom. If it happens, then you got to do some of your best writing, because you got to figure, I don't know if I'm going to get in front of this judge. If I'm not, my only chance to be in front of him or her is going to be probably before a law clerk that's going to be reading my written work. And so I think that's where our craft comes into play. This is really a craft. And I'll tell you, I know that the attorneys on this broadcast, I think, are largely 10 years and younger, 10 years and less experience. And I'll tell you, my first several years of practicing were the slowest ones. They're the ones that took the longest. They were the most difficult for me. And then stuff started speeding up as I developed my own practices and learned the craft. I started learning the craft, which I still learn today. I still learn new things every day. And so I think it's important when you're writing, if I'm writing to a federal judge, U.S. magistrate judge, U.S. bankruptcy judge, or a district judge, or the circuit, I'm really thinking that I'm writing to his or her law clerk. Don't get me wrong; those judges are all really smart, but nobody has probably the brain power or the dedication to that one particular issue, my issue, than that law clerk that's assigned that case. I'm not saying that to pander to the law clerks. I'm really not. But it's just the truth. And they're going to then, sounds gross, they're going to digest it and regurgitate it for me, the judge. And I'm sorry if that's too graphic, but that's what they're doing. They're saying, okay, and they're going to put their slant. It's human nature. They're going to have a position on that. Maybe they're defense oriented. Maybe that clerk is plaintiffs oriented. I don't know. I knew my judges well enough in different locations throughout my career as a litigator that I kind of knew if depending on which clerk drew the case, was assigned the case, I kind of knew how it was maybe going to turn out. I mean, that you can get to that point where I think you're that intuitive, and you should, if you're familiar enough with them. The good thing about federal judges is they typically stay for a while with life tenure for Article 3s and above. Well, Article 3s, district judge and above, and then 8-year terms for magistrate judges. And I can't remember, 14 years maybe for bankruptcy judges. I can't recall. But they're going to be there for a while. They're not having to run for re-election all the time. Praise the Lord. That would be very difficult to do. But so you ought to be able to develop sort of a book, if you will, on each judge, sort of things you know and things your partners know, your other associates know, that will help. And so as you're writing as clearly as possible, as briefly as possible. They're called briefs for a reason. And I know a lot of people want to be, a lot of lawyers want to write books. This isn't the time to write that book. Write your memoirs later. Write your book on the side. That's great. And most attorneys are good writers. Not everybody is a good writer. Not everybody's built for appellate work. Not everybody's built for trial work. But be succinct. I come from the old Army school where we wrote by way of what we call BLUF. BLUF, bottom line up front. And so I always used to say to my attorneys that work for me, we do bluff, we don't do puff. And so I wanted to always have that. I want to put it up front, and then I want to support what I've got. If I've got a weaker position, I put that later. I don't hide it, and I go ahead and admit, so that typically the court knows. If I'm going to concede on something, I'll concede on that, but I'm not conceding on my primary issue or issues. And that way, I've kind of got it before the judge. If I don't get a hearing, even if I want a hearing, if he or she doesn't give me one, or if I don't get a proper hearing, like a hearing where I really have an opportunity to put it out there, because everybody's busy and they're not going to want to spend a lot of time, even though we all know how important that is. So those are just a few things I would sort of give you on that.
Mm-hmm. So I have a question from the audience, and you're speaking to a lot of young lawyers, so we're concerned about our time in the courtroom and time in front of judges. So, and there are some other federal courts that have a program to encourage courtroom time for younger attorneys. What's kind of your thoughts on how younger attorneys can get heard in front of a motion? Or for a motion, and then is there a wheel for young attorneys to take on smaller matters?
Yeah, we don't really have a wheel unless they want to. I mean, we don't go out and solicit. I do encourage all the older attorneys, more experienced attorneys, to bring with them, someone who can be involved. And a lot of times they'll turn it over, a hearing over to a younger attorney, a less experienced attorney. We have certain things, we have prisoner litigation cases. Tell you what, somebody wants to do stuff like that, it's a good way to dip your toe in the water. When I was a young attorney, the federal system was this abyss that everyone was scared of, at least everyone I ran, my crowd that I ran with. We were just all scared of it. I talked to an attorney, a colleague of mine in Austin when I was practicing there, and he did some federal work, and he said, actually, I kind of like it better. And so I started looking at it, and I do too. It's been 25 years since I've litigated in a state court case, litigated in a state court at all, but in any case. But I think we have panels for criminal cases, and I know people scoff at that, especially civil attorneys. They feel like that might be beneath them. I just don't. I think anytime, I love courthouses. I love the system. I love lawyers. I just like the smell of a good courtroom. I don't know what, it's just weird, but many of you are sitting there going, nodding your head with me right now. No, you are. Because you just need to get in and drive around. It's just like any kind of app on the web. You have an app or anything. You want to get in there and drive around. Otherwise, you're not going to know what all it'll do for you. And you get in, get to know not only judges but their staff. You get to know courtroom deputy, who's the most important person in the courtroom probably, to the lawyer, to the judge, the court reporter is, I think, because we've got to take everything down and be perfect, and hopefully she'll make you sound smart and stuff. But so you can always get on a CJA panel. The judges are not going to throw you into the briar patch. We're not going to throw you into something heavy. We'll start you slow, I promise. If it's just hey, I want to come in and get my feet wet a little bit, and I want to extract, I don't want to stay and do this type of stuff, no problem. We got plenty of cases you can do that on. If you want to do some appellate work, we've got some stuff that you never have to appear in court. You prefer to research and write. We do that all the time. And so we've got opportunities like that. Like I say, prisoner litigation, whether it's any type of writ or 1983 issues, all kinds of things, which, who knows, with the things that are going on here currently, not to comment or give an opinion on that, with all the peaceful protests / rioting and looting, whatever it may be, and with all the police brutality claims, I think we're going to have, this is going to be a hotbed for that type of litigation. And to me, frankly, maybe it's a mental defect of mine. I don't think, I was told, get in the courtroom and practice. That's why we call it a practice. Get in there and practice. Don't come unprepared. You got to be prepared. That doesn't mean you walk in and just get beaten around, like a pinball, because you want to win the day. And I think you start getting familiar with the courtroom, familiar with working with staff and judges, and before long, you feel like you kind of own the courtroom, and you do. You own a piece of the legacy of the courtroom. And it's important that we do everything correctly. I love courtroom demeanor as well, and that's one thing I kind of like. When I stepped out of state court into federal court, that's one of the reasons I wanted to do it. I wanted to write more. I wanted more of a written practice in addition to in person, but I also like the formal nature, the demeanor of everybody, and that's important as well. Fewer cases than the state's having to deal with. State, good grief, it gets overrun, and I've been there as well. So it's important to jump in there. Just, you can give us a call, and I have sort of an open door. You might imagine this is not Dallas, and I love Dallas, but I don't want to do this in Dallas. I mean, I love New York. I've visited. I don't want to do this in New York. I want to do it where I am. It's akin to sort of a country practice, and I see people on the street, at the local grocery store, not only practicing our courts every day, but people that I have sent to prison and they've come back, or they're on supervised release with me now, or whatever. My gym, same thing. I see people at my gym all the time, and that's what I like. I like the give and take, and the making of our communities better. And so, anything you want to do, here at least, I don't know if it's everywhere, but here at least, you make a phone call and we'll set up a meeting with you, and we'll talk about what you want to do and what we believe you can do to help.
Awesome. So, question from the audience: how do you like to handle DAYL hearings? Would you are witnesses, and do you prefer that they're in person?
I do. I do. And I still call them Daubert hearings. I'm sorry. I know that a lot of people would call them Daubert, and it doesn't matter what you call them. Voir dire, whatever you want to call any of that. Of course, we're in West Texas, so we're gonna put as much slang on it as possible. Slang. I like them in person. I like to know ahead of time. What I don't like on Daubert hearings is, this late notice, and then all of a sudden it's the day of trial or jury selection, and we're having to throw that in as well because I want to do a good job for you. And so the more notice we can get of that, and sometimes, believe it or not, I know this is hard for some of you to believe. Many of you will understand it. There's not even really a declaration of an expert, but the law clerk sort of sniffs it out, if that makes sense. This law clerk will come into me and say, "Well, they're not saying this, but here's what I think they need," and so that'll protect your conviction or your settlement, your resolution, your jury verdict later by doing it correctly up front. And the way you do it correctly is the more notice, the better. And that lets us do that. And we do those. I do those in person. I haven't done one of those by Zoom. I suppose we could if we had an expert in Australia and who couldn't get here, or there was some type of travel issue. I wouldn't be opposed to it. Of course, if any of you watched the SpaceX launch the other day and the connecting with the space station and all that, those pictures are amazing because I was a kid when they first landed on the moon. I remember watching, you could barely see, it's so grainy and everything. Now our comms are so much better. And it's almost like I'm sitting in the same room with you, Jenny, right now. So would you, real quick, would you put up slide number 2 before I forget? This is what my mom thinks that I look like at work, just so you'll get a picture of that. So that's what my mom thinks I look like. So go to the next slide, and you'll think what I think in my mind I look like. There you go. And so I always feel like I'm a warrior, and that I'm defending, justice and the system. And I was telling Jenny before we started, you think I'm talking about Brad Pitt, but there's a guy up over above his right shoulder that's out kind of blurry watching. That's really me there. But anyway, so that's what I think of when I think of that. Okay, you can take those down. So I just wanted to show those. We wanted to use our audio visual tools a little bit here.
Mm-hmm. People are really into hearing about hearings. So when handling a motion for summary judgment hearing, is it a good practice or your practice or the courtroom that attorneys lay out all their full arguments, or do you think it's better to act as a hot panel type of judge? I think asking questions who addresses narrow issues and difficulties with the parties' respective positions.
Man, that's a good question. And that sounds like a question from somebody who's got some experience with one or the other or both.
It does.
I tend to start, and I'm not going to give you a fair or a clear answer on this. I tend to start, and keep in mind, a lot of times we don't have hearings. We'll have it, we'll do it on the written work. And so I think you want to lay out your best argument in that motion. And I think those are few and far between where we grant those. There are some, though, that are appropriate, and where they're appropriate, I know there are some lawyers and judges who think you should almost never. I'm not in that boat. I don't think you should almost never grant a motion, such a motion or summary judgment. But I do think that it's rare. It's more rare than the other. And what I typically do is when I have a hearing, I expect the entire thing to be laid out. Now, and so that's what I would prepare to do, because you never know. Even if somebody has a reputation of not doing that, some judge, you never know when it might be they sit there and listen and let you just roll. And if you're rolling, why would you want to stop? If you're making a persuasive point or points, I don't think you'd ever want to stop. At the same time, while your opponent may not be doing a great job and may not be prepared, I don't think you want to stop them if they're not doing a great job. I don't know why you ever, would want to interrupt them when they're kind of blowing it. That's sort of my theory on that. I will say that there are certain cases where I fully understand the issues because it's been digested for me, as I said, by the law clerk, and I've studied it. There are some cases where I have more questions. And so there are times when, if you think there are particular questions, they're going to come up, I'd be really ready for those. And so there are times where I'll salt and pepper, the litigator with some, the advocate with some questions. But there are always going to be questions, I think. but I'm more of, everybody talks about Justice Thomas, Clarence Thomas, not asking questions, and they're thrilled when he does. But you go back and look at, for example, patent cases that he's ever been sat on. Not only has he asked most of the questions, he's written most of the opinions. It's just a matter of each judge and what their particular interest may be or how much understanding they may have. So when I first got here, there may have been an issue on a patent question on say something that's a downhole camera at a drilling unit site. Would have been interesting to me because I grew up around that type of stuff. I grew up in West Texas, or what we call West Texas, or farming, stuff like that is of interest to me. But I might not be particularly adept at understanding what your particular issue is with that. So I think you got to come in fully prepared to educate. But also, you've done a good job of doing that with your brief, with your motion. And so when you get here, you're ready to go either way, either direction, and you won't be caught flat-footed. You got to prepare for everything, especially the worst-case scenario. I know some judges, that are a few senior judges now, and maybe some who are retired, who they didn't really want to hear that much from the advocate. And maybe it was because it was me and they didn't want to hear from me, but there were things they had so much experience in and so much background in. Maybe that Judge Ferguson, Royal Ferguson, had a lot of experience he was a savings and loan attorney back in the 80s in the savings and loan crisis. Well, there's not a whole lot that I'm going to tell him that he doesn't know about that. But I've got to go in assuming that I need him to know that I know it and I understand it. And so that's kind of where I would go. So my answer to your question would be prepare for the full-blown hearing, and then you got to adapt whenever you get there and do maybe a soft shoe dance around certain things. There are going to be some things you get asked about that you don't know. I think that's going to happen. You've got to prepare for everything you can. In the major leagues, they say when you get up to the Major League Baseball, it takes you some time to get used to the speed. Same with pro football. It takes you some time. The speed of the game is so fast. Well, I think court is very similar in that it's a fast pace if you're not familiar with it. But that game, as you get more experience and you're in there more, it slows down. I don't know what it is about it, but it slows down for you. And you see the fastball coming across the plate or the curve. You recognize the curve earlier. You anticipate those issues. And I think when you see a really good experienced lawyer, so it doesn't have to be that experienced, but you can recognize it. You can see it. And I was taught that I could learn from watching good lawyers and poor lawyers. And I think I have. I've tried to. You can learn almost just as much from the poor lawyers because you realize, okay, I don't want to do that. Or I don't want to do it that way.
Yeah. Well, thank you so much, Judge Counts, for your insight, your tips, and your really, really solid advice. I want to make sure we wrap here, even though I'm sorry we didn't get to all the questions. Again, the CLE code is 174088309, and we have another Coffee with the Court coming up on July 8th with some of our Eastern District judges, and another Coffee with the Court on August 11th in the morning at 8:30 with a judge from the Fifth Circuit. So we're trying to round out the state with our lovely federal judges. So thank you so much again.
Thank you. Thanks for having me. I appreciate it. Enjoyed being with you.
Yeah, great.